final matter to come before us this morning on oral argument is Erick Jones versus Carrols LLC et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and you wish to reserve any time for rebuttal, if you let me know, I'm keeping the clock and I can let you know about the passage of time. We have read the briefs, we're ready to see when you are.
May it please the court, Bob Kerper here on behalf of the appellant Erick Jones. I would like to reserve 5 minutes for rebuttal. I'm going to spend most of my argument at this time not on the necessarily substantive matters that I think have been analyzed and described in our briefs. The thing that I want to address is the Arnold case, because as I'm sure the court is aware, it's been cited in the briefs, and the judges may have read the Arnold case. It's a case out of the 8th District Court of Appeals, which basically held that the identical arbitration agreement, which is present in this case, in an employment discrimination case, was basically unenforceable, not a valid contract, was unconscionable, and illusory. Obviously, I believe that the Arnold case was correctly decided. I believe it is persuasive authority for this court, and that this court should follow the Arnold decision, and likewise hold that this was not a valid and enforceable agreement. It's illusory, lacking in consideration, violates public policy, and basically is an unfair agreement which I think, as the court described, basically tried to include everything that could happen in an employee's life, whether he was working for the employer or not. Now, the appellees, Burger King, obviously attempt to distinguish Arnold. Basically, their distinctions don't hold any water. First of all, they claim that Arnold isn't dispositive in this case because in Arnold there was a rape, and that somehow, and the intentional tort of the rape, takes Arnold out of the normal employment discrimination cases, and therefore the Arnold holding should be limited simply to cases of rape. The problem with that argument is that that's not what Arnold held. Well, obviously Arnold did address the issue of rape. It basically talked about intentional tort cases. For instance, in this case, Mr. Jones, obviously we don't have a case of rape. But we do have an intentional tort of invasion of privacy. We have an intentional tort of defamation. We have an intentional tort of infliction of emotional distress. The bottom line is both Arnold and the Jones case involved an employment situation where there were also intentional torts which were outside the scope of employment, but which under the employment or the arbitration agreement that was implemented by Burger King, according to language in the arbitration agreement, the agreement applied to even to intentional torts that occurred outside the scope of the agreement. Now, the appellees also try to argue, that it was simply a case of rape. Well, that's not true. If you read the Arnold decision, you will see that this was an employment discrimination case. The lady claimed not just sexual assault, but also a hostile work environment, aiding and abetting by the employer, also included negligent hiring and retention. No different than the Jones case. Jones, again, he claimed employment discrimination based on race. He claimed a hostile work environment. He claimed aiding and abetting and conspiracy, and he claimed intentional torts. So basically, the background facts of both cases are exactly the same, except that there's a different intentional tort. And they try to say that makes a difference. The problem is that intentional torts, by their very nature, are outside the scope of employment, are outside of employment. It's fortuitous that the person that commits the intentional tort happens to be a co-employee. I mean, if Mr. Jones, for instance, in this case, Mr. Jones' defamation was that Mr. Jones, they claimed that he was a thief, that he he stole money from Burger King. Well, the point is that if Mr. Jones had been, let's say he was a customer and came in, and while one of the front people were handling a matter, reached into the cashier drawer and took some money, they would claim that he was a thief. The defamation, he didn't steal money, the defamation would apply regardless of whether it was a co-employee who would defame him or whether he was a patron or employee. It doesn't matter. Intentional torts are by their nature outside the scope of employment and as I said, it's fortuitous that the person who committed the tort was either a co-employee or the employer. The other thing about the Arnold decision is that while the Arnold court did indicate that rape being an intentional tort was outside the scope of the agreement, it also found that the agreement was both procedurally and substantively unconscionable. Now that would apply to the agreement regardless of what the intentional tort was. Also, the Arnold court held that the contract to a degree was illusory. That would be true regardless of what the intentional tort was. The Arnold court found that the Jan's rules, which were to apply to this arbitration, were basically incomprehensible to a lay person. The judges themselves attempted to determine what the cost of arbitration would be to somebody, and they couldn't figure it out from the information they were given. Those flaws remain regardless of what the intentional tort is. The ambiguities in the agreement, the one-sidedness of the agreement applies regardless of what the intentional tort was. Here you have an agreement which basically favors the employer over the employee in terms of what claims can be brought. For instance, class actions. There's a class action waiver. Basically, an employee can't bring a class action. Well, that's fine. Can you imagine Burger King bringing a class action against a single employee? It would never happen. It's totally one-sided. Same with some of the substantive provisions in the arbitration agreement, which basically says, well, yeah, all these things have to be arbitrated, except you don't have to arbitrate confidentiality issues. Well, basically the only party that would do that would be an employer who would basically be claiming in court that they have injunctive relief because somebody is disclosing confidential information. So all of these things apply to this case regardless of whether it's a rape, whether it's defamation, regardless of what it is. So I would argue to this court that the Arnold decision is exactly on point in this case. It's the identical agreement. It's the identical same type of case. It's an intentional tort case. Language in the agreement is the same. The provisions in the agreement are the same. The steps that Mr. Jones would have to take are the same steps that Mrs. Arnold would have taken. And I would ask the court in this case to basically follow the Arnold decision and hold that this agreement is not a valid or enforceable agreement. It's unconscionable. I make a public policy argument. I think that has some basis. The one thing that I do want to address to the court, if I have time, is an issue that was not directly addressed by Arnold, though there was some indication in there that Arnold believed, that the Arnold court believed that this was an illusory agreement. If you look at this agreement and you look at the employee handbook, which was given to the employees, and which basically states right there that the employer, as to any policies in the arbitration agreement, in the handbook, which included the arbitration agreement, was basically the employer could change the terms of those policies at will, without the consent of the employee, without any knowledge to the employee, without his allowing the employee to opt out. So basically, there was no promise. It was illusory, because whatever the agreement said, Burger King could change it whenever they wanted. And in fact, they did. In fact, I used the examples in my brief. There are at least 2 instances where Burger King changed the language of the agreement as to how much it would cost or how much the employee would have to pay if, in fact, he wanted to proceed with arbitration. Now, if it's an illusory contract, there's no consideration for that, obviously, because there's no promise. You're not really promising anything. You're just saying, here it is, and if I want to change it, I'll change it, and tough luck to you.
And
So-
you're just now reaching that 5 minutes. You
Okay.
reserve for continuing.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Catherine Miller, and I represent the appellees. I had a feeling that Mr. Kerper might lead with Arnold, and so I will address some of the arguments made by him. Obviously, contrary to Mr. Kerper, we strenuously believe that the Arnold decision does not apply to this case for a couple of significant reasons. Number one, no evidentiary hearing was held in the Arnold matter, as even this court recognized in connection with its decision issued after the 2015 argument. It was not for the appellate court to make findings of fact, and thus this matter itself was sent back down for the trial court to make a determination with respect to whether Mr. Jones possessed actual knowledge of the agreement. That wasn't done by the appellate court in Arnold. There was no evidentiary hearing, and thus there were no facts in the record for which the Arnold court could actually rule. Second, the Arnold court specifically said that the arbitration agreement was unconscionable as applied to this case. The court did not need to include that language. It could have made a blanket finding that Carroll's map was unconscionable across the board, but it did not do so. And I believe that was because the Ohio Supreme Court has recognized that you need to have a factual analysis on a case-by-case basis. The Hayes Court specifically found that in determining procedural unconscionability, you need to look to facts in the record. There were no facts in the record in Arnold. As an example, the Arnold court engaged in a discussion about the costs. There was no evidence in the record with respect to costs. If there had been evidence in the record, as there was here, the Arnold court would have known that Mr. Jones was only responsible for paying half of the JAMS filing fee, or $200, which is not inconsistent with a filing fee before a trial court. With respect to some of Mr. Kerper's claims with respect to intentional torts, the Arnold decision was also wholly grounded in Arnold's sexual assault claim. The substantive cases cited by that court were all sexual assault claims from Mississippi and South Carolina and the 11th Circuit. And I would note that even in some of those cases, the courts there found that the employment claims, the pure employment discrimination claims, were subject to arbitration. Those are not wholesale findings that simply because there was a sexual assault alleged that meant that everything was out of the picture with respect to being sent to arbitration. Of course, the appellate court in Arnold found that everything was, nothing could go to arbitration. We clearly disagree with that finding, especially because there really was no discussion of any of the other claims in the Arnold opinion. It ruled on the sexual assault, and then it moved on to its unconscionability analysis, which here again, we believe that because there was no evidentiary record to make any findings, it was improper for an unconscionability finding to be made. Would also note that we cited to a 5th district opinion that actually overturned a trial court ruling because the trial court failed to conduct an evidentiary hearing in connection with a motion to compel arbitration. With respect to the intentional torts alleged in this case. Yes.
Can I back up a little bit? I guess I have a couple questions, and before you get to all your stuff, maybe I better ask them or I might forget. I know that this was sent back down, remanded to the trial court for a determination
To be honest, I don't recall if there was an explicit finding, but I think that it was inherent in the decision and that the court found that Mr. Jones possessed actual knowledge and that the claims were subject to arbitration and sent them to arbitration.
And I also, so it must be your position that the trial court would make that determination, not the arbitrator. I know that's not really necessarily argued here, but we always have those arguments too as to who, which comes first, the chicken or the egg. And so is it your position that the trial court did not have specifically find that it was subject to the scope of the arbitration agreement? Because obviously that's one of the assignments of error.
Correct, and I know that courts differ on this issue. Under the FAA, it would be our position that once something is sent to arbitration, it is ultimately up to the arbitrator to decide whether that claim remains in arbitration or is not subject to arbitration.
Because in looking at the original trial judge's order, that was really very brief and there wasn't much in there at all. So, and since this was one of the arguments on appeal, I was looking to see what the court's reasoning was as to why it was within the scope of the arbitration agreement, and I really didn't find any neither order, so that's why I was asking.
Yeah.
So it's your position, just by sending it to arbitration, that the court has implicitly made that determination?
Or has determined that it's a decision that should be made by the arbitrator if anything falls outside the scope of the agreement.
Okay, then that goes to my second question, the court sending it to
Maybe I
arbitration.
should have stopped.
No, no. You're fine.
You're gonna get it anyway.
Anyway, get it out, that's right. Then the second question is, what did the court really do here? Because if you look at the court's order, the last order that we're on appeal with now, it says, it is therefore ordered that defendant's renewed motion to compel binding arbitration and motion to dismiss the complaint shall be granted. Did he order it to arbitration? Did he dismiss the case without ordering it? What does that mean? It's a little unusual.
In light of the previous order where he sent it to arbitration and granted the motion, it would be Carrols' position that yes, that he granted the motion to dismiss and that he intended that the matter be sent to arbitration.
So by granting the motion to dismiss, you're saying in essence dismisses the case, even though the court doesn't say case is hereby dismissed or case is hereby ordered to arbitration?
We would take that position. It was a combined motion to compel arbitration and to dismiss. And I believe that was the intent of the order, although I will not profess to speak on behalf of Judge Gallagher.
Mm-hmm. Well, and I'm not trying to be picky, I'm just trying to make sure because it's just a little different than I'm used to seeing.
Yeah, no, I believe so. I don't think that Mr. Kerper and I would be before you today if we were under the impression that it hadn't been sent to arbitration. But I agree that Judge Gallagher would probably be in a better position to address his language, but I think that was the import of the decision.
Thank you. I think I'm through for a while.
Okay. With respect to Mr. Jones's intentional torts that he has alleged, it is Carroll's position that those torts do fall under the arbitration agreement, and that is because the arbitration agreement is explicit in stating that it covers any and all claims arising out of or relating to your employment. And Mr. Jones himself, with respect to his intentional infliction of emotional distress claim, alleges in the complaint that, quote, as a direct and proximate result of the extreme and outrageous conduct of defendants, end quote, he suffered emotional distress. With respect to his constitutional claim with the implementing statute, it is for a record of his wages. Now, it is true that letter was not sent to Carrols until 2013, but there's no reason why that letter had to be sent in 2013. That letter could have been sent immediately after Mr. Jones's termination. Here again, Carrols contends that arose out of his employment. To request wages from your employer, it arose out of your employment. The same with Mr. Jones's defamation claims. While a specific time frame is not pled in the complaint, he alleges that taunting remarks continued after his termination. Here again, those remarks based on Mr. Jones' own allegation started during his employment and continued thereafter, and so it's Carrols' position that they still arose out of or related to his employment. But even if the court would find that the intentional torts are not subject to arbitration, we still believe that his employment discrimination claims most certainly are subject to arbitration, and that has been upheld by the Supreme Courts and courts in Ohio across the board. The U.S. Supreme Court in the Kindred nursing case recently affirmed that you simply can't single out arbitration clauses, and in that case, the plaintiff was seeking to require an explicit waiver of the right to a jury trial. And the Supreme Court said you can't do that. That is something that affects arbitration only and seeks to single out arbitration. That is one of Mr. Jones's arguments here, that he did not explicitly waive a right to a jury trial, but that is not required. The arbitration agreement explicitly states that in agreeing to arbitration, you are giving up your right to go to court. With respect to the procedurally and substantively unconscionable arguments that were raised in connection with the Arnold case, the agreement is not illusory. There were no other versions of the agreement that applied to Mr. Jones. The agreement that applied to Mr. Jones was the agreement that was implemented on August 1, 2006. Mr. Jones was given notice of that agreement as far back as July 10, 2006, in a memo from Carrols that went to all of its employees that attached a copy of the arbitration agreement. With respect to the JAMS rules, the Arnold court did not make a finding that they were incomprehensible. And in fact, we cite to a case in our briefing that actually specifically upheld the JAMS rules and found them commendable as compared to the rules at issue in the case. Because the JAM rules, there are procedural rules of fairness. Mr. Jones is entitled to weigh in on the choice of an arbitrator that is generally a federal or state court retired judge. There are safeguards in place in the JAMS arbitration. It is not a one-sided agreement that guarantees Carroll will win. In fact, with respect to the 2 Ohio JAMS arbitrations that Carroll's had in the past, we have a 1-1 record. So there's nothing that demonstrates that Mr. Jones is not going to be able to get a fair hearing in arbitration. With respect to the class action waivers issue, obviously there's not a class action at issue here, but class action waivers have been upheld in the employment context, and as I'm sure you are all aware, the Supreme Court is going to definitively decide that issue in the fall term. This is not the identical type of case that was at issue at Arnold. As Mr. Jones concedes, there is no sexual assault at issue. There was an evidentiary hearing held here, and there was not one held in Arnold. The Ohio Supreme Court has found that you need to look to the facts of the record in determining unconscionability. There was no fact for the Arnold court to look to in determining whether the map was unconscionable in that case. With respect to Carroll's handbook, it is not a contract. It explicitly states on the handbook that it is not a contract and was never intended to be a contract. Carrols is well aware of many cases in multiple courts that have found that a handbook is not a contract. The map agreement itself is a contract. The map agreement itself is a 2-page document. It's not in fine print, and nowhere in it does it provide that it can unilaterally be changed by Carrols. Nor was the August 1, 2006 agreement unilaterally changed here. To the extent that any other versions of arbitration agreements have subsequently issued, that they have no impact on this case. Mr. Jones is only held to the agreement that was in place on August 1, 2006. I think that it should also be remembered here with respect to Mr. Jones' arguments that the trial court, who is in the best place to determine Mr. Jones' credibility, was not so kind with respect to him. They found his testimony elusive and non-responsive, disingenuous, unreliable, and self-serving, and that his demeanor on the stand caused the court to disbelieve him.
You have about 30 seconds if you want to wrap up. I
Your Honor, I thank you for your time. I believe that I've covered the substantive arguments and that everything has been addressed now twice in briefings before this court, and that you are all fully informed with respect to the matters, and we would just ask that you affirm the trial court's decision. Thank you.
Thank you, counsel.
May I please the court, I want to address first this evidentiary hearing issue. Now, Burger King argues that one of the reasons you can distinguish Arnold is because there was no record. Well, there's no record in this case either in terms of unconscionability or scope of the agreement or anything else. Basically, as the court remembers, you sent it back to the trial court for finding whether there was actual knowledge. And that's the only thing that the court addressed. I mean, basically, there was no evidence presented by Burger King at the hearing or at any other time regarding unconscionability or the scope of the agreement. Their whole emphasis on, as if the court remembers at first, was that we gave reasonable notice. Then this court basically said that's not enough under Ohio, was there actual notice. So it went back down, they presented no more testimony, and the trial court basically found that there was actual notice. There was no finding of facts regarding unconscionability. There was no finding of facts regarding the scope of the agreement. There was no finding of facts or legal conclusions regarding the Arnold case, which I cited to the court before he made his decision. So to the extent that they're trying to claim that Arnold was different because there was no evidentiary hearing, well, there was in a sense, there was no evidentiary hearing here either in terms of unconscionability or the scope of the agreement or public policy or illusory nature of the contract. The court didn't address any of that. All the judge said was, you sent it back to me to say whether there's actual knowledge, so I'm going to find there's actual knowledge. And that's it. So the case is in no different position than the Arnold court was. More only, it's important to remember that the Arnold court was a court of appeals. They were taking this on a de novo review. So obviously, they reviewed the record as it was, and they believed and found in this case that there was sufficient record from the very agreement itself and from the pleadings that this went far beyond the scope of any kind of arbitration agreement, that it was unconscionable for a numerous number of reasons, and that regardless of whether there was a factual record below, apart from the pleadings and apart from the briefs and everything else, they didn't need it. They didn't need any more information. The only information they really needed was to look at that agreement. And to be honest with you judges, you look at that agreement. If you were a lawyer, would you ever allow your client to sign something like that? Nobody would. I mean, this thing covered from birth to death any claim he would have. She doesn't talk about the fact that some of these claims were 6 months or more after he was not employed. How is there any consideration for an agreement when you're not even employed by the entity? I mean, there's no consideration there. It's unbelievable. Mr. Jones's credibility. I agree with Ms. Miller that at least as to the issues of actual knowledge, the court found that Mr. Jones was not credible. But he made no such findings regarding his other testimony, for instance, regarding his economic situation, regarding his knowledge of arbitration, his sophistication, his lack of education. There were no findings by the court, nor did the court indicate that, and all those things Mr. Jones testified to, there was no finding by the court that he didn't find that information credible. The only credibility determination he made was that because of the circumstances that were presented, that Mr. Jones had actual knowledge of this agreement. And I think the court understands that just because you have a notice of agreement doesn't mean you agree to it, doesn't mean you understand it, doesn't mean that you know that it will apply after you leave the employment of the employer. There's no testimony or information given to the court that would support that finding. Now, the other argument that was made here that I think I need to address is this language that only applied to this case. Well, that's true of any decision. When you make a decision in this case, that decision is only going to be binding and holding to that case. Now, it can be used as authority, persuasive authority, it can be used to compare or contrast, but the holding in this case, just as in the Arnold case, only applied to that case.
And counsel, regretfully, I need to let you know you've utilized your 15
Okay,
minutes.
thank you, Judge.
Thank you. Thank you both for your presentations this morning. The court will take the matter under advisement. We will issue a written decision, which will be mailed to both sides as well as posted on the Supreme Court website. Though the court is now adjourned until Tuesday,